Again, yes?
Well, first of all, I want to thank all of y'all for coming. I really appreciate it. It's been informative to people like me who have no idea about patent law. But I have a question. I noticed each one of you have touched on a different basis with court decisions and mostly how you disagree with them. What is your biggest thought on, like, what's the biggest thing with patent law, the biggest infringement that the court is now touching on? What are you most worried about, I guess, in patent law with recent court decisions, is, I guess, where I'm going.
Well, okay, I just talked about litigation, so I'll start. I can't say that there's any, I mean, there have been some big decisions that change how cases are litigated. Arguably a big one was a case, another federal circuit reversal where, and this is the Supreme Court kind of fighting back at the patent troll problem of that injunctions, meaning ordering the defendant to stop infringing if he loses, are no longer automatic. And it was meant to penalize some plaintiffs who just sit around and license and don't do anything, which is universities, for example. But they said, no, this won't apply to universities, they're special. At least that was their suggestion. But I'll say more practically on a day-to-day basis, you know, I can't say the average case that walks in the door addresses any of the issues I just had. But the biggest issue is there's still, it's very technical law, it's very technical science, and the whole patent process is very technical. It's not meant for lay people to even understand. And judges, you know, like here in Jacksonville, I would say if anyone can guess what probably 80% of the docket is, it's drug cases. You know, we're in a port city. Judges don't see patent cases there, and so they don't always get them. It's a luck of the draw. There are some judges that like, there's no judge that likes them. But there are some judges that are more comfortable with them than others. And so even though you have a case, somebody walks in and you think this is very clear, there's always a lot of uncertainty. And that's probably still the most frustrating thing. And I would say that's the biggest challenge still. And the AIA and all these, they may simplify things in some ways, but litigation is just as complex and difficult.
Do you have a thought?
May I? On the most significant issue, there is a case currently pending before the Supreme Court, and I don't have the complete site here. It's on my tablet over there. But I refer to it as the BioSig case. So let me give you a little background on that. One of the more difficult areas and one of the more uncertain areas continues to be claim interpretation. So you've got this wonderful patent, you've got this nice claim that somebody has spent a lot of time drafting, and the parties have spent millions of dollars arguing over, and just precisely how you interpret that claim and what the rules are for construing it are still a little bit fuzzy. We had the AWH case a few years ago that really helped out a lot in terms of the procedure that you're supposed to go through, but we've still got some issues on how you interpret the scope of a claim. A simple thing. You'd think that after several hundred years we'd be able to interpret claims fairly easily. But the BioSig case and some of the amicus briefs were recently filed this week go to the issue of when you find a claim to be invalid because it's indefinite and you can't interpret it. And there are phrases being batted around, insolubly ambiguous, and other kinds of phrases. And unfortunately, it's gotten to the Supreme Court. And Herb has told you a lot about how we feel about some of the decisions of the Supreme Court. They have a tendency to grab things and make some changes that we find difficult to follow. And the situation with the BioSig case is just one of those. And if they come out one way or another, or they start saying things that we're going to have trouble understanding, it's going to take years of litigation for us to figure it out, so that we can advise clients, so that we know what we've got when we're done. You buy a truck, you know it's a truck, and it's got wheels, and you can see them, But when you buy a patent or when you go to assert a patent, it's intellectual property, and it's difficult to define. What I tell my students is, and I tell in arguments and cocktail parties with other attorneys, is that the patent claim is the most difficult legal drafting that there is. And I have yet to have any attorney that practices corporate law or securities law or any other kind of law give me a convincing argument as to why that's the case. Not the case, I'm sorry, not the case. So we're still struggling with claim interpretation, and the BioSig case is one to watch. If you're interested, I'll email you a highlighted copy of the Court of Appeals decision, and you can see what the issues are. And I would recommend that you read that, and if that comes down badly in the Supreme Court, we're in trouble.
Thank you.
Thank you. All right.
Infringement litigation. Coming off of what you just said, Professor Hawley.
Just Jeff's good.
Is the percentage of litigation that occurs in litigation higher than the average percentage? In essence,
I'm not sure I understand the question.
Do patent attorneys litigate more than any other attorney, or the average of attorneys?
In my experience, our profession is much more like what you were talking about. There are a lot more attorneys that are a lot more patent attorneys that are creators rather than dispute resolvers. So I had a staff of 50 attorneys, and I had 0 of my attorneys did litigation. We all created property, out of thin air. We created property. It was fun. It wasn't resolving disputes between people where people are at each other's throats. So the vast majority of patent attorneys do preparation and prosecution, and some people look down on that. The litigators think that they're these magnificent people who have gone beyond that, and I look at it differently. I think the people that prepare the patent application and do it carefully and do it well are worth their weight in platinum. So the profession is highly centric in terms of numbers to people who create and advise clients and do the licensing rather than litigation.
Can we just set the groundwork that you can be a patent attorney and help prosecute patents, for which you need to have some sort of science background? But fret not, for those of you who don't have a science background but again are still drawn to this, you can certainly be, a fruitful and productive patent litigator. Either
you can be a better patent litigator,
yes.
Actually. Litigation is something that an aptitude that it seems to me you're a little bit born with. And good litigators can litigate product liability, patent suits, whatever they get into, and they dive into a litigation and they learn whatever patent law they need, they learn whatever technology they need. But if they are good persuaders to the court and the jury, that's the key to winning litigation, not being a great patent attorney and understanding secondary considerations in 4-part harmony.
I'll agree with that. Best litigator I knew was a merger and acquisitions attorney from Sullivan and Cromwell in New York, and decided to get in the patent litigation business. And he was the brightest person I've ever seen. He comes racing into my office one day and says, "What's this DNA crap all about?" And we sat down for about 40 minutes. I gave him a tutorial. At the end, he asked the 3 most important questions. And I knew he had it, and off he went and litigated the case. It was just amazing. So they're a special group.
If I could add to that, I certainly agree. I was a non-traditional law student, and the first time I had a professor that was younger than me was my patent license drafting course. And the visiting professor didn't have a technical background, and that's actually the first point she made in her first class. And I agree that you do not have to have a technical background to be a darn good litigator. She even started off with an example of how she explained to a jury that also does not have a scientific background atomic diffusion. And being a materials engineer, I said, "Oh, I can't wait to see what she says." And I'm thinking of an example in my head, and I thought of, atomic diffusion through a composite. I thought of a peanut butter and jelly sandwich, and how atoms have to diffuse through peanut butter. It would be slower through peanut butter, but maybe faster through jelly if it gets to the jelly. And she actually came up with a sandwich with Swiss cheese that had holes in it, and the holes represented the vacancies, and she did a far better job than I ever did with my technical training. So
You know
I
you're in
definitely
trouble
agree.
when people start using analogies. I learned that this morning.
Thank you all for being here today. My question's for Mr. Vermouth. You touched on it briefly, and it was also in Professor Reid's bio. What is a Markman hearing?
A Markman hearing, okay? Hardest thing to draft is the claims of a patent. And because the claims are what define what's known as the metes and bounds. It's just like when you purchase property, you have the deed and it has a legal description. And the purpose of that legal description is to show where your property, what the borders are. So if I step here, I'm on my property. If I step there, I'm a trespasser. Claims do the same thing, or they attempt to define what is an active infringement and what is not. There was a debate many years ago as to, so when you assert a patent in litigation, the fight, or the real trenches are fought over what do the words in the claims mean. And so I guess you use the example, I know a screw from a nail. So if it says something like, okay, well, and where it's a bolt, and turns out somebody interprets the bolt as not having threads and mine has threads, there's going to be a fight over what bolt means. And because whether that term is interpreted one way or another way, it's pretty clear whether there's an infringement or not. And there's really nothing even left to decide. So the question was, who decides what the claim terms mean? Is it the jury who's going to read the patent and try to figure it out? Or is there just too much there, it's too technical, let the judge decide it? And the Supreme Court in a case Markman versus Westview determined it's up to the judge to decide what the claims mean, and then the jury will get the interpreted claims and then figure out whether the accused device meets them. That process of having the judge hear the evidence, whether it's an actual hearing or it's on paper, and having him hold a hearing to decide what the claims mean, that's a Markman hearing.
Thank you.
Sure.
I tell my students to watch the docket in the federal district court in Concord, New Hampshire. And if there's a Markman hearing come out, I excuse them from class. Go listen to that Markman hearing. That is one of the best things you can do to see what you're getting into if you decide to go into patent claim drafting or litigation. Unfortunately, they don't come up very often. We talk about all these cases and how wonderful they are, and they're cases decided every week. But in the scheme of things, there are not a lot. Of opportunities to go sit in a Markman hearing and listen to attorneys argue for 2 days over what the word adjacent means. And so I would say, I'm hearing that there's not much patent litigation in
It's actually on the rise.
Jacksonville,
It is rising. But I mean,
watch
again,
the docket. If there's one, petition the court for extra seats, and everybody should go.
you won't have to do that, actually. You'll be, but I mean, again, like, if you look at the cases, it sounds exciting, and if this is what you enjoy, you'll enjoy it. And I would love to be able to sit there and watch them, because you always learn something from watching somebody else and how they manage, prepare, and present and argue a case. But there's a case out there where there was a 4-day Markman hearing on the meaning of the word particle. So,
Good stuff.
It is great stuff.
This is for Abby. Could you explain the Office of Commercialization, exactly what it does?
Sure. As was mentioned a bit ago, universities are special, quote unquote, where we don't necessarily, quote unquote, do anything, and we rely on others. We are the creators. A big misconception is that universities conduct a lot of R&D. The amount of development we do is almost nil. We need an existing company to do that for us, or a startup, or a spinoff. So the Office of Commercialization, we are the liaison between the university and that industry to actually do something, is the simplest way to put it.
Do people bring ideas to you that you pursue a patent?
Yes, sir.
Okay.
Well,
Mostly from funded research.
from within the university.
And students do approach us as well. We can take their intellectual property depending on the circumstances. If, for example, if they use significant university resources, or if they're employees, graduate assistants, then we will have ownership. But in most cases, as far as students are concerned, we will not take ownership of the intellectual property.
What about the public?
No.
No, okay.
Yes, the Bod-Dole Act that you heard about earlier this morning gave universities the right to retain ownership of federally funded inventions. And the theory behind that was the federal government's no good at commercializing this. Let's give it to the universities. Well, we sat there and said, we're the ivory tower, we ain't no good at it either, just to be honest with you. So it was only about 30 years ago that universities created what are called tech transfer offices. We just happen to be called the Office of Commercialization. So we're a fairly young profession, so to speak.
Hi there, my name is Andrew Rush. I'm a patent attorney here in Jacksonville for PZ2 Law Group. About half of my practice is software-related inventions. And at the federal circuit level, CLS Bank versus Alice Corp, not a majority of the court, but a big chunk of it sort of said, maybe software patents are not, 101 subject matter. And now it's before the Supreme Court, so I was really interested in your guys' opinion on how that case might be decided, and more broadly, is software something we should be patenting?
Well, I guess I'll take that one too. I'm terrible at predicting what the Supreme Court's going to do. I've been wrong so many times that it's. It was alluded to here a little bit about the eBay decision on when a patentee can get a permanent injunction, and the Supreme Court decided the case of Kello versus the City of New London. I don't know if you've studied that at all. That was the eminent domain case in New London where the city wanted to come in and build and turn over a large parcel of land to a developer, develop this shopping mall, the theory being that that was going to improve the tax rates. So the Supreme Court, with an opinion by Justice Kennedy, who was the swing vote, I believe, in that case, found in a way that I said, oh, now, I can predict what's going to happen in eBay. I was wrong. So I'm a terrible predictor. I can tell you what I hope. I hope that they leave the door open for a substantial opportunity for people to figure out ways to patent software, for want of a better term. It's an industry where the United States leads. There's one of the reasons we lead, and that's because we've had the ability to patent software for a long time. You can't patent it in a lot of countries. I used to teach a course in comparative patent law, and it was alluded to this morning, there are laws that have restrictions. One of them is you can't patent software. And I firmly believe that that is one of the reasons that our industry is as strong as it is, because you can get patents on software. A lot of people don't like that. I'm not a popular person in some circles, but I believe that providing incentives to that technology is just as important, if not more so, than providing incentives in other areas of technology, and I think it should be patent eligible. Whether they're going to do that or not, I have no idea. If a client were to come in to me today and they say they've got a little bit of money that they can put in my pocket, I would advise them to absolutely file the patent applications, do the best you possibly can in writing the claims so that they look like they're machines instead of bits and bytes, and just do your best, because those are valuable inventions and they should be patent eligible.
Mr. Concard?
I agree with him saying that the Supreme Court is known for being unpredictable, and I would advise you to do what he advised at the end, is claim the apparatus. And software is pretty much ubiquitous, and there's hardly anything that we use today, whether it's your refrigerator or perhaps your toaster. So does that mean the toaster is not patentable? My sense is they have to find a way to cover the apparatus, even if there's software included in it. If it's a general purpose computer, you may have to make it a little more specialized. Europe is an area where it's sort of a first battleground for these kinds of issues. I think you're probably aware that in New Zealand and Australia, they pretty much said you can't. That's going to hurt them. There's a public policy issue here. There would be incredible fallout if they just were to say software patents are invalid. And I can't imagine we're ready to take that fiscal hit as a nation. So my prediction, based purely on the money, follow the money, is that they won't completely eliminate them. But they may give guidelines on claim drafting. And I also agree that one of the reasons that claim drafting is so difficult is the guidance changes and how you do things and what's patentable. And if you go to the PTO site, there is specific guidance on software patents, and most of that is probably not advisable to follow. Claim the apparatus. Claim the apparatus, and you'll do much better.
Good afternoon. I'd like some practical advice. I'd like to know, how does an American toy manufacturer protect himself with patent when the Chinese knockoffs come out like 8 weeks after the product comes on the market? Where's the jurisdiction lie, and where do they get the protection from? We have clients make a product, and within 2 months the product's on the shelf coming from China.
That's yours. So there's several ways. Assuming that your market is America, then there is Section 271 protects against an article that's made according to a process that's claimed in a patent. So what you do is you have a patent that claims a method of creating your toy, and you can stop it at the border, hopefully. There is a growing patent community in China. It's a little uncertain as to what's going to happen if you try to assert in China. From what I have heard is that if you have a Chinese partner and the Chinese partner sues a Chinese company that is infringing, then your odds of success are much higher. And most people realize that personal property was just against the law not so long ago in China, so certainly patents were. There is a growing number of Chinese patents, and they're reasonable to get. I would probably advise your client to get the Chinese patents and at least have them. It's better than not having them. And the uncertainty of assertion would be better that you have them, partner with a Chinese company to make your toys, and have that Chinese company sue the other Chinese company.
Rich?
Yeah, something else you can do, at least at a minimum, and this is, you already have your US patent, is it can be difficult, depending on the value of the product and the market share. Most American companies don't want to litigate in China, and they definitely don't want to litigate in Taiwan. You can't litigate in Taiwan if you're an American. I mean, just to put it simple, contracts are unenforceable in Taiwan. I mean, but what you can do is, if it's sold in the United States, other than on a website where they're shipping, where you can physically, you can cut off, I guess, their distribution outlets, and hopefully the fact that brick and mortar locations or Amazon or somebody else is offering for sale the product, you can have it pulled off of shelves, perhaps in those situations. And again, because a lot of the big boxes and all, they don't want to get in the middle of a patent dispute. They're going to push it back on the supplier and pull it off the shelf until it gets figured out. So you could do that, and that's a more practical way, but it's not going to solve your problem. Because again, what do you do about the internet sales that are, orders are being filled outside of US jurisdiction, or where you're just playing a cat and mouse game and they're going to pop up somewhere else?
Let's talk a little bit about an ITC action under 337. Quite a bit different than patent litigation in the district court, where you go and sue somebody for infringement, and you're looking for injunction, you're looking for damages and attorney's fees and the whole 9 yards. So you bring your action in the Southern District of New York, and you find where they're selling the toys, and you go after them, etc. An ITC action is different. An ITC action under 337 seeks to stop the importation of the offending device at the border. So you bring a complaint, and in the ITC you request an exclusion order to exclude those bad things from coming into the country. And it's an in rem situation. It's an in rem remedy. It's against the goods. It's not against the manufacturer at all. You stop things at the border. And we talk about patents a lot here because that's what we know and love. But there's the ITC has much broader jurisdiction than that. And there was a very interesting case that I talk about when I travel to places like Taiwan and etc. And in that particular case, the ITC issued an exclusion order based on the fact that a trade secret had been stolen in China. So all of the offending acts regarding the theft of the trade secret occurred not anywhere near the United States, but within China itself. And so the question in the case was whether the ITC had jurisdiction for bad things that happened in China as the basis for an exclusion order. It turns out that they do. So it's not just patent law, it's anything that you can convince the ITC to meet their exclusion order requirements, which are harm to a domestic industry. If you are having your toys made in China too, that's probably not going to do you, not going to be the best for you. But if you've got a U.S. company making U.S. goods for U.S. consumers in the United States and somebody knocks it off and tries to bring it in over the border, look to a 337 action. That's another possibility.
Yes, sir.
What kind of protection do you get from a trademark?
You'll have to ask a trademark attorney. Those guys are crazy. Look for the people with the Mickey Mouse ties. Those are the trademark attorneys.
Because I deal with small companies, sometimes you are the attorney, and we do some trademark work. It'll give you branding protection. So what it does, if you generally think of patents and trade secrets and know-how protecting the product, the trademark will protect your branding and your marketing. And that's oversimplified, but if you think of it that way, and copyright will protect your works of art, your anything written, code or copy, and trade secrets could be almost anything that you don't think you can protect adequately the other ways, or just decide not to. But if you think of trademarks and branding, that's probably the best we can do in this one.
What it does for you is to identify the source of the goods. So what happens for a trademark owner, and it's the public, doesn't have to think about whether this is a good product. I recognize this product because I recognize the trademark. It must be a Sears tool. That's going to be that Sears brand's going to tell me that's going to be a good tool. We had a case, I was talking at lunchtime when I was patent counsel at SmithKline Beecham. We had a drug. It was a patented drug that was going off patent, and the generic companies, of course, were lining up to market the generic form of the drug, and it was Tagamet. And what we did at SmithKline was to make the pills green. That was part of, it's called trade dress, but it's part of the trademark law, and people would associate green pills with being Tagamet. Just you hear about the purple pill, right? And what happens?
I never heard about the purple.
What happens? The patent is about ready to go off, and we get wind of the generic company not only making cimetidine, which is the drug that was going off patent, but they're making green pills. And so, we couldn't stop them from making cimetidine. The patent expires. That's the rule. You get 20 years of exclusivity. Now the public gets the right to make it without coming to us. But they don't have the right to make them green. Green doesn't have anything to do with cimetidine. So what we did was we sued them for trade dress infringement. And it takes 14 days to run the cycle. And you say, big deal. You stop them for 14 days. Well, at the time, we were making $1 million a day off that drug. And you couldn't pay the patent trademark attorneys not to bring that lawsuit. But that's the kind of, because they were trading on our goodwill of people associating
Confusing
green,
the source.
confusing the source.
At what point, after you've got your provisional, do you file the trademark? Or are they filed
No,
simultaneously?
you're talking about patents.
Independent.
Two different things.
Two different things.
Are they filed simultaneously?
No, patents are for the inventions, trademarks are for the brands,
Right.
and there's no provisional trademark.
Okay,
So it's,
but,
they're two different sides of your brain. You got the trademarks over here making a mess, and you got the nicely ordered patents over here.
I'm sure you're familiar with the proverbial rush to the patent office that was emphasized when we talked about AIA earlier. It's important to note that you don't want to necessarily rush to the patent and trademark office for a trademark because you have to use the mark in commerce in order to receive that protection. You can file what's called an intent to use trademark application, and you have 6 months to show that you're using the mark in commerce. You get an additional 5 6-month extensions for a total of about 3 years. So you want to time that correctly, if you will. And it's also important to note that the term of trademark protection lasts so long as the mark is used in commerce. So you don't want to lose it by not using it. But you could have perpetual mark, perpetual protection.
We have a question over there.
Hi, I have two unrelated questions. The first is going back to the Markman hearings. Are the results of those appealable?
Yes, and actually that was the subject of a recent Federal Circuit decision. But it is appealable. And again, this is the trial court judge making the decision, and then it would get appealed. And again, that's a problem. You have a slew of rules, just like contract construction, and you can fight over what contract terms mean. It's the same thing with claim construction, and depending upon which of the rules you emphasize versus others, you can come up with different outcomes. And in fact, there's cases where there was a preliminary, and well, let me step back. When you appeal, sometimes they're released before the Phillips AWH case, depending on which 3 judges on the Federal Circuit that got assigned to your appeal, you could get a different outcome. And in fact, there was a case where there was a preliminary injunction sought at the beginning of a patent infringement case. The court had to do a claim construction. That got appealed. A 3-judge panel reversed it, came up with its own claim construction. And so the judge is like, okay, I'll apply that through the case. End of the case, appealed again, different 3-judge panel, reversed that claim construction. It happens. So yes, it is appealable, and the Federal Circuit just came down with it. One of the big debates is, should there be any deference to the trial court judge? Meaning, look, he heard, sometimes he'll hear testimony from experts on what a claim term means in the industry, but should we give him any deference, or can we look at it and make our own decision? And the Federal Circuit said no deference, and so things aren't going to change, but yes, it is appealable.
Wow, that's a mess. Sounds like fun for appellate lawyers. But then the other question is, what advice would you have for a first-year law student wanting to get into patent law as far as summer jobs go?
Summer job, I think everybody can answer that. It's tough. You know, I mean, it's hard enough for a first-year law student to get a job doing any kind of law. But you know, I guess it's possible. But I can tell you, you know, in my experience right now, this is still not, the economy still hasn't recovered, and so I would say it's tough, but not impossible.
All right, thank you very much.
Come see me.
In our situation, I'd echo that. The first year, between first and second year, it's tough. There's no question about it. Somebody who's finished their second year, I would say it depends on their technical background in patent law. If you're a double E, you're in good shape. If you're somebody like me with a chemical engineering background, it's a little tougher. But so it depends a little bit about your willingness to relocate for the summer and your technical background and how well you did in my class and other kinds of stuff.
Well, if I could add to that, I started law school in the fall of 2008, and we were basically told good luck getting a job, and When someone mentions they were a summer associate, I don't even know what that means. I think I know what it means, but that's just not in our vocabulary. My summer job turned into my current full-time position. I joined the Intellectual Property Law Students Association, and I networked with attorneys galore, and there was nothing. Now, what I did do is I networked with the president of the Intellectual Property Law Society, who had the position that I took as an intern because he was graduating. So don't ever underestimate networking with your own upperclassmen, especially. That would be my advice.
And I believe that if you have good writing skills and research skills, there's a lot of preliminary work that companies need, and they're often in a hurry. And so what they will do is take your work and feed their lawyers. And so if you are local and you have those skills, feel free to contact us, and I'll try to put you together with the correct clients.
Attend as many alumni events as you can. We have one very good alumni in the Boston area who has his own firm now, and I think he's got 6 or 8 of our students that he's hired over the years, and the firm's doing very well. He's on our board of trustees and hires lots of our graduates, provided they do well in my class.
One of the hot topics that we hear a lot about is patent trolling, or patent enforcement entities, or non-practicing entities. Can you give a brief synopsis, perhaps a balanced view, pro and con, and then does that open up more jobs? Will there be more litigation, patent litigation jobs? Patent trolling.
Well, someone asked before if I had issues with the courts, and not so much the court, but if we're going to legislate to give certain patent holders deference over other patent holders, I see all sorts of implications for that. And what is a troll? What is a non-practicing entity? So does it behoove me to make 3 things and sell them? Now I sell something. And it's a fallacy. They're creating a fiction because people don't want to license those that innovate. And even if the people that have done the innovation sell their patents to someone else that will insert them for them, they don't want to be accountable. And so my view is that the law is the law, and during much of the industrial age, it favored the large companies, so they kept it intact. Now that the tide has shifted and it is easier for other people to get patents, and often those people are smaller entities that don't have the wherewithal to enforce them themselves, there's another industry closely related that is investing in lawsuits. There's a huge effort in Australia for people that will finance litigations, and it's growing in New York. So they will come in, assess your litigation, and sue for you. It's actually a way to get around patent trolling. The investment returns are, I've heard, between 30 and 38%, and it's much more hands-on. So if you go buy IBM stock, you have to hope that the people in IBM do the right things, and you're putting your faith in them. If you invest in a patent litigation, you have a lot of say in how your investment's going to go, whether you want to settle, whether you want to take certain actions, whether you want to bring in experts for a Markman hearing. So I think that the trend will be financed litigations, and my hope is that a patent owner has the same rights no matter who you are.
Don't be fooled, there are patent trolls out there. Now, what is a patent troll? There are abusers, and I would agree. It seems every time somebody there should be an exception for some really, 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 really good invention that everybody needs, and so they shouldn't have to pay royalties. And that's actually an abuse the other way. And an example was when there was the anthrax scare after September 11th, Cipro, I think was the drug, became a necessity, and this company's with the patent on it, it's about to make a lot of money. It's like, well, wait a minute, they're being greedy, and it's like, no, that's exactly what patents are meant to reward, and they don't owe anybody any discount. You take into account what they spent to develop the drugs. But when your client gets a letter that it turns out that all those years where they took a document and they scanned it into their copier and they got an email in their Outlook file that converts it to a PDF, that's infringing, and you have to take the number, and they give you a form with the number of employees you have times $10,000 per employee, and send us the check. And when your client gets this letter, they see that it was sent bulk mail, bulk rate paid, because there's a company out there that simply goes to the business journals in every town and sees the top 10 real estate companies. They all must have these copiers. No pre-suit investigation. They just mail off mass form letters hoping people write the check. Do they ever sue the copier company who designed the product and who has the money to fight it? No. And in fact, if you were the first person who hired an attorney and brought a declaratory judgment action or defended the suit and dragged in the copy company, that the plaintiff all of a sudden settles and walks away from the case because they want to go after the guys that can't fight it. Now, is the patent legitimate? Probably not. I mean, it's very questionable. If it was, all the copy, they would have gone to the big players, the copier companies first. Because if you go to the source, they'll pay some, you can enter into a license that would cover all their customers. Now, that one seems to be an abuse because they don't want their patent challenged. And maybe it's business acumen, and they're being smart, trying to get the most they can at the lowest cost. But on the other hand, there are people who, there is everyday technology that does infringe a patent that hasn't been asserted. And that somebody owns it. And so it's kind of hard to differentiate the legitimate patents from the ones that are only valid and collecting royalties because they haven't been challenged yet. And they go out of their way to not attack anybody who has the financial incentive to take that step. So I mean, I guess, now is it fair to pass legislation that punishes everybody? No. I think what they're proposing, at least some of the more reasonable legislation, would be that there's a little bit more of a responsibility on the patent owner in certain circumstances to do more of an investigation, identify who they are, not put these patents in shell companies and you never know who the owner is, and it's hard to get any meaningful discovery because the company that owns it doesn't have any documents relating to its prosecution. But there's abuses, and I wouldn't say that everybody who asserts patents in mass is a patent troll. And some of them there's a lot of innovation that's being infringed with a lot of abuses, but that's my take on it.
There's at IPO we did a 2-day seminar on trolls, 2004 or 5, something like that. And the issue that both of you have alluded to continues, and that's the definitional one. What is a troll? And there was a recent conference, and one of my friends went to it and asked around various people that went to the conference. And the definition ranged from a troll is anybody who sues me, to the kind of abuse that you're talking about. The person who will buy a questionable patent will make a questionable interpretation of the scope of the claims, and we'll send out mass letters and hope to catch a few people that are willing to settle for less than what it would take for them to do the internal investigation. That is the classic kind of troll. Just as a point of history, and somebody will have to fact check this for me, but the person who invented the term patent troll was Mirwald at Microsoft, who went off to be one of the founders of Intellectual Ventures, who is sometimes referred to as a troll. So, it depends on whose ox is being gored as to whether it's a troll or not.
Troll is in the eye of the beholder.
The troll is in the eye of the beholder.
All right. Any last questions from you guys?
This is for Mr. Picard. You were speaking earlier about the change after the AIA from first to invent to first to file. Mm-hmm. My understanding was it was kind of somewhere in the middle where it's the first inventor to file. If that's true, does that change the analysis of an inventor kind of keeping a record log to be able to fight someone that runs to the office first?
I'm glad you're asking me to clarify that. You can only file if you're an inventor. That's correct, or on an inventor's behalf. So I can't watch you do something and file it in my name. I'm not an inventor. So you do make a declaration after the claims are written that we've spoken about, that you're essentially swearing that you are the inventor of that invention. As far as it's not as much date sensitive, as long as it precedes your filing of the patent, but it is always good to have a notebook, and I didn't mean to infer that you shouldn't. I'm a huge proponent of inventors' notebooks, and if you can, electronic now is a wonderful way to do it too. So keep good records, it's always a good idea.
So I was going to say, one thing he left out is the Mr. Kincard employment line is going to start right over there. There's plenty of work out there. I mean, there's as many people, everyone in here, if I interviewed you long enough, I'm sure I could make your inventive seed sprout, and all of us can be innovative. So it's just those so inclined to do so. And I think the more important part that was alluded to, we need to have a climate that we encourage innovation, because all of us can be innovative.
That's a very happy note to end on.
Okay.
I like that there are jobs for all of us. Well, I think we've had a fabulous symposium. We started with a 103 analysis on non-obviousness, 101 patentable subject matter. We talked about drugs and mid-sized pharma, if not big pharma. Talked about design patents and how groovy they are and what the advantages and where they overlap with trademarks. Provisional patents and file early and file often, and some of the changes under the AIA. And then we also talked about enforcement and what licensees' abilities and rights are. So I think we've covered a wide terrain. I think you guys have been amazing. I thank the school for giving us this opportunity, and hopefully you'll stick around and come up to us and ask questions. But now I think we'll have the editor-in-chief of Florida Coastal Law Review come on up for some closing remarks. Thank you very much.
Hi, I am Amanda Ingersoll. I am the editor-in-chief of the Florida Coastal Law Review, and I just wanted to take a second to thank everybody for preparing for, participating, and attending our symposium. Special thank you to our speakers for sharing their knowledge with us today. Thank you to the Florida Coastal faculty, the administration, our faculty advisors, for lending a helping hand whenever we needed it. Thank you to Dr. Reid, our moderator today. I would also like to thank the Florida Coastal Law Review Board, the staff members, and the candidates for all the help that they have given. And obviously, this day is a culmination of months of preparation, meetings, phone calls, planning. So a very special thank you and congratulations to our symposium editor, Dr. Sharifi. For our law reviews to publish a visible and forward-thinking journal that influences and engages the legal community. So another special thank you to all of our local inventors and local attorneys for attending and participating today. I hope you'll look forward to, as much as I do, the issue of our journal that will ultimately result in this symposium. Along that note, for anybody that has not registered with us, we don't have your email to contact you to send you any of the materials. So at a reception afterwards, I'll make sure to provide a list so you can sign up, give us our email so we can contact you. I promise it'll just be with stuff for the symposium, so no worries there. We do have a reception afterwards. Everybody is invited to mingle, happy hour, if you will. It is downstairs on the first floor. It's in the atrium, sorry. If you take the elevators, just go down to the first floor, walk towards the back of the building, towards the lake, you can't miss it. You have to walk right through it. So without any further ado, I'm going to pass the mic off for some final closing remarks to our president of Florida Coastal Law Review, Mr. President Dennis Stone.
Thank you very much. You know, I have a soft spot in my heart for intellectual property. In my 25 years of teaching, I was occasionally teaching intellectual property, and part of that, of course, was patent law. About 40 years ago, I was in law school, and we were very interested in intellectual property and patents, but it was a totally different world back then. In fact, the boom, the post-war boom of patent filings reached its peak just about 2 years after I got out of law school. And it dropped significantly to a point of 50,000 patent grants in the 70s. And then, of course, it has risen now to a significant amount. So one of the things I thought I would kind of bring people up to the top of the trees before you go home, to think about the value of this effort, particularly in patents, but also copyrights, trademarks, and don't forget trade secrets and other related intellectual property activities, the value this has to the economy and to individuals. If you look at filings in 2013, there were 600,000 patents filed and 300,000 grants were actually made. Now, there's been a much more, you know, the world is flat, there's been a global impact, a lot of foreign patents have come into this, but you can see a significant increase. From a world statistics, there were 2.5 million patents filed in 2011, which was a growth of 9.2% over 2000 and the previous year. This was the highest number in 18 years. So to say that somebody said there's a lot of work. There's a lot of work, there's a lot going on. If you look at the value of trademark, of patents, I did some digging, and the best study I found, it's an older study in 2005, but they surveyed over 20,000 patent holders, and they got responses from 9,000. This was an EU study. And they indicated that the median value of a patent back in 2005 was 300,000 euros. You can do the math, maybe multiply by 2 back then, but worth a lot of money. That's the median. 10% of the patent owners reported that there were values of 10 million euros. 10% of them, the value was 10 million euros. And this was just the European Union, not the United States, Asia, etc. In terms of copyrights, claims in 2011, the latest report from the Copyright Office, 539,000 claims. And in trademarks, 450,000 applications in 2013. So there's a lot of activity, it has a lot of value, and obviously individuals acting in this area, inventors, creators, have an interest and need help from the legal community. So I mentioned these statistics not only to really indicate the value of the role of the practitioners that are here, the inventors in this activity, but also for the students to realize the value that's there. And if you have an interest in this area, you should take the advice that you've heard today. Get engaged. If you have a passion for this, if you like what you've heard and you like what you've learned from your professors, I don't care what it is. You know, another area that I love to teach in is maritime law. It is not exactly a hot topic in the percentage-wise in the legal profession, but I love it. And the people that love it find jobs, they find interest, they go after it. So I'm telling you, if you really like this, go for it. Network, learn everything you can. Pay attention to the Invent America Act, or America Invents Act of 2011. Pay attention to that. That's something that people are going to be looking at. It's just now hitting the profession. And that is one reason, by the way, why we're very interested in developing an initiative that will engage our students, supervised by lawyers, to assist entrepreneurs in getting them set up. A large part of that is intellectual property, trademarks, copyrights, patents. So we're very excited about that, and we want to encourage you to listen to these, the faculty that have been here today, the practitioners and our faculty members, because it's a great opportunity for you to do something that's very exciting. I want to close also, as Amanda said, by thanking all of you for participating, our speakers, the staff and faculty for putting on this wonderful symposium, and of course the law review for their great efforts and all the efforts they make in their great journal. So thank you very much, and I wish all of you a good evening and a great weekend, and enjoy the reception.